Ishita, shall we start?
Yeah, okay, let's start. Others can join in slowly. Okay, hi everyone. I'd like to welcome you to our webinar on the Digital Personal Data Protection Bill, published by the government a couple of weeks back. I'm sure most of you are aware. So, for those who don't know us, we are one of Asia's largest data practices, housing 14 data lawyers who spend most of their time thinking and reading up on all things data and privacy. Uh, Again, most of you are familiar with Matthew already, I'm sure. He's now a globally acknowledged leading data practitioner. Our second speaker for today is Adya, who is the youngest recognized leader in the data bar in India. Matthew and Adya will also be joined today by Ajit, who focuses on cybersecurity and issues pertaining to minors' data. Right. So for this section, as with any other webinar, we'll have a couple of house rules. We will take you through our thoughts and comments on the bill, after which we'll open the forum for questions and discussions. If you have any questions during the presentation, please send it to the Q&A box that you can see at the bottom of your screen, and we will address the same as soon as possible. I think we can now begin with the session. Matthew, over to you.
Thanks, Ishita, for all those lies. Anyway, so Adya, is this iteration number 5, 4?
This is the fourth version of the bill. Yeah.
This is the 4th version of the bill. For all those who are unhappy with the number of iterations and the time this bill is taking, I must tell you that before we came up with the 2011 Reasonable Securities Procedures Bill, there were 4 iterations of that, starting with the 2003 NASCOM Data Protection Bill. And strangely, I've been writing articles and notes on all of those bills. I've probably written articles and notes on about 10 different data protection bills in India. And consistent with practice, this bill is not much better than many of those before it. And that'll be a strange admission for someone who, ever since I landed up in India from Singapore, after a decade in Singapore, I've been telling people that rather than looking to the EU GDPR for a precedent on how to draft a comprehensive bill, we should look for Singapore law on how to do this, because it's rather than a quantum jump, it's a more manageable jump in terms of data governance principles and ethics. The government's done that, not in as nuanced or sophisticated a manner as I kind of wished it would be. In places, some of this looks a bit amateurish. But by and large, I think we've got the rudimentary guardrails for a new data bill. And if you speak to the government, they're very, very clear that this is not the final set of comprehensive rules that the Sri Krishna committee set out to, bring forth. These are just the skeletal basis of a new law, right? And the government intends, and the Data Protection Board, I'm sure, and multiple other regulators in consultation with the government and the Data Protection Board, and MeitY and Certain and all of them, will probably play a role in fleshing this out, right? So as far as possible, Adya, Ajit, and I will stop crying over conceptual issues that we may have over the bill, and try and focus on what is it that we have, and what is it that you as council in different organizations should look at and know while thinking about this bill. There are constitutional debates that the three of us have spent nights over. arguing vociferously on whether cross-border transfers will be impacted and yada yada, all of that. We're going to stay away from that because largely that is theoretical, and we'll try and stick as far as possible to the practical. And I'll do the easier bits, and Adi and Ajit will, of course, obviously do the more complicated, tougher bits. And the first bit's fairly easy. Before we go on to what the bill says, what is the bill trying to solve? What was the problem with the earlier bill? It was very, very clear from the earlier bill that they'd taken the GDPR, done Control F over words like controller, replaced it with fiduciary. And for all those who've read the earlier bill, and mind you, that there may have been more coherence in that bill because it incorporated the lived experience of the GDPR, but it was a lazy form of legislative drafting. People had changed names here and there and incorporated the same concepts into a country where perhaps some of those concepts required revisiting. So shame on that committee. But what is this? What are the key points that the earlier bill had, which the government is trying to solve? It did have some slightly crazy localization norms. I've seen media articles in defense of those localization norms. I'm sorry, that is a misunderstanding of how data works. Today data for it to be treated efficiently has to travel across national boundaries. This government's come up with one particular scheme for those national boundaries. They've let go of certain other core principles, which I wish they had not. We'll talk to them, we'll try and convince them that this has to be made easier. But the idea underlying this bill is that we're not going to insist, as long as our data subjects' rights are protected, we're not going to insist that data be localized and stored in India. Should we do that for national security and critical information infrastructure? Perhaps. That probably will come in the form of rules at a later date. The second criticism was that a heavy compliance burden was placed on startups and SMEs. While this may have been appropriate for jurisdictions where startups do not provide the excitement and kind of the rocket fuel for the economy, that clearly is not the Indian economy. And we can't overburden startups with, and small and medium-sized businesses with detailed data rights. On the other side, startups have the tendency to cause as much harm to me as a data subject as a large company, right? Just because you're not a $1 million company does not mean that you can take my data and do whatever you want with it. So there are questions which, if any one of you wants to have a cup of chai with me, I'd be happy to evaluate. There are questions of whether this will survive the 14, 19, 21 inspired Puttaswamy tests. Let's leave that aside, because I've promised Adya and Ajit that I will not indulge my tendency to go on a constitutional challenge. But as the bill now stands, as the earlier bill stood, one of the big criticisms was that the requirements were onerous for small and medium-sized businesses. We've got certain amount of relaxation of that already built into the bill. More stringent removals are apparently being thought of, depending on a data threshold or a business revenue threshold. I'm not a big fan of just saying companies below a certain amount of revenue will not be asked to comply with it, because that's just a large hole that lawyers like Adyami and Ajit can sit and work on and fix. But perhaps companies that do not deal in data sets less than X amount can be provided some level of exemption from some of the provisions of the Act. And that's something that I understand the government is thinking about very actively. So hopefully we'll have some resolution over that. The other controversy that came up was sweeping government exceptions. Typical Indian government, or actually typical global government data grabs. Why are we criticizing the Indian government? The government can intercept a lot of data and have powers of wide-ranging powers that are perhaps inconsistent with Puttaswamy. Those powers, by and large, remain. We've got to evaluate whether enough of a supervisory mechanism has been put in place for government access to data. Probably not, but one hopes, uh, with the sword of Puttaswamy hanging over the government, perhaps that government regulations on how it accesses data of Indians and Indian data subjects will probably be the subject of a different regulation, perhaps a different act that deals with it. Let's not cry too much about sweeping government exceptions. Our government is under fairly large constitutional strictures, probably have courts, and the way Justice Chandrachud is going at it, we probably have courts stepping in to limit government powers. So again, I think a little bit of the public weeping over sweeping government exceptions is drama that probably is not called for at this point. Finally and thankfully, that silly nonsense over non-personal data has been laid to rest. I love being proved right. Did from day one tell all clients who would listen to ignore that rubbish, and that's what it is. Hopefully, the government has thrown it in the bin and does not intend to revisit it. However, chain of consequences, both the Singapore government as well as the European Union government are looking at ways to govern non-personal data. And if that does happen, whoever came up with that silly nonsense has much to pay for. The last, and this is something which I think three of us on this call spent a lot of time crying over, which is this over reliance on consent as a ground for processing. We thought that was slightly amateurish. If you look at the lived experiences in Europe, or if you looked at the lived experiences even in countries like the US and countries in various comparable common law countries where there is a privacy law, you can see that technology demands a move away from consent and the idea that you can take my consent and do whatever you want to do, to a more responsible data governance architecture that includes consent or notice as a important part of it, but you're not relying exclusively on it, and there are some things for which you cannot take consent. That's the way the government has built that into the act has been inadequate in our view. That problem has not yet been solved, but hopefully with multiple electoral victories under their bag now, the government will go about solving the slightly more complicated issues of processing of data by private entities. So that's my broad overarching view of the politics and reality of the data bill. Adya, do you want to, since listening to my voice alone probably has already started getting boring, Adya, do you want to take over the next bits?
Sure. So what we're doing, what we intend to do, like Matthew mentioned, is maybe focus on more of the practical aspects and how these affect businesses and things that organizations might need to start thinking about. While the law is still in the draft form, and we know that the ministry is open to feedback and consultation, we expect that these skeletal aspects will remain to stay. So what we thought about when we were putting this together was to focus on actual operational takeaways that organizations might find useful. Now, Matthew touched upon the key issues with the previous versions of the bill. And in some ways, this bill addresses them. In some ways, they do it well. And in some ways, the way this version of the bill tackles some of the previous controversies remains lacking. So broadly, what we see is that consent continues to remain the primary ground for processing data. which basically means that when you compare it to other jurisdictions, whether it's Europe, whether it's Singapore, and these are the clear inspirations for our existing bill, the over-reliance on consent for a country with the kind of linguistic diversity, with the kind of educational diversity, with the kind of literacy levels spread across the region, relying on consent may not always be the most sensible or the most appropriate choice when we think about collecting data. And we're going to touch upon consent more, but we can't avoid it. And while the bill creates other grounds for processing data. By what I mean by that is, in the absence of consent, or if you fail to collect the consent of individuals, while you're processing their data, the bill does allow other exceptions, but they're not very well defined and somewhat lacking. So by and large, businesses, companies, organizations will have to depend on consent to collect data. And that we'll see brings its own set of compliance challenges. Localization, which was a huge issue and probably one of the blocking grounds for why previous drafts and previous versions of this bill didn't go through. The localization requirements have been removed under this law, but what you end up finding out is that the way cross-border data transfers are structured under this existing law is based on an adequacy decision that will be issued by the government. So there are no other grounds for transferring data to other jurisdictions. And we'll come to see that becomes very problematic. And in my view, imposes a soft localization requirement on businesses. The last thing is security remains an integral part of the bill. I think a key obligation for businesses is to ensure that you've got your security protocols in place and you do what you must do to prevent personal data breaches. You will find that the corresponding penalties for a failure to comply with this requirement can go up to, I think, 250 crores, which is, I think, amongst all the existing laws in India today, one of the highest penalties that is imposed. So there's a lot to be scared about, but I think there's also a lot we can do to get ready for this. So let's jump into consent, because I think that's a key issue here and brings out some of the more compliance heavy obligations and burdens. Now, broadly speaking, when we say that consent is the primary ground for processing personal data, it means that all organizations must, in the absence of an express obligation or provision within the law, seek an individual's consent before you collect or process their personal data. Existing Indian laws also require consent for the collection of certain types of data, but existing Indian thresholds for consent are extremely low, right? Under existing law, you can technically deny services, while individuals can withdraw consent. It's not very commonly used or commonly implemented. There are not very onerous obligations on businesses to inform individuals how their data is being processed. So broadly, under this draft of the law, consent needs to be free, as in freely given. It must be a choice that you give individuals. It must be informed, and we'll come to the how individuals must be informed, because that's a huge compliance challenge. It must be specific, and it must be an unambiguous indication of an individual's wishes. So while the law doesn't use the term explicit consent, for all intents and purposes, we are looking at explicit consent requirements when you are collecting personal data. What this means is that organizations are going to have to rethink how they collect data in the first place, whether it's through an app, whether it's on your website. Every part of your app journey or your user journey and the corresponding collection process needs to be rethought. What we also find is that the law imposes an obligation on businesses to provide individuals with privacy notices before they collect the data. And this is interesting because these privacy notices, or your privacy policies in common parlance, must be made available in English and 22 other languages prescribed by the Indian Constitution. It's not a choice. You can't choose either or. It comes down to the fact that all organizations must have in place processes to make your policies available and your requests to seek consent available in 23 languages. It's actually a welcome move, I think, considering the diversity and the linguistic diversity of India's internet user base. But it also means that you need to know very, very competent translators who will help you kind of navigate the privacy notice process. And the privacy notice can't be the traditional legal jargon that I think we lawyers get away with. It needs to inform and educate users of how businesses use their data. And while the law doesn't really prescribe, additional requirements, I wouldn't be surprised if they came out with, if the government issued additional rules requiring pictorial or video representations of how businesses use data, so to make sure that individuals actually understand how their data is collected. Another thing that comes up when you're thinking about consent is, what about data that we collected prior to the enactment of the law? Do we need consent for that data? And I think the law is slightly oddly worded. Matthew, Ajit, let me know if you disagree with me, but I'm not very, I think that's where the law is lacking, where the language of the law, and I'm sure it can be fixed with a few drafting tweaks. But right now, it appears that you don't need to retake consent for data that was collected once this bill, prior to the enactment of this bill. However, you do have an obligation to provide data subjects and individuals with the privacy notice. So essentially, when you're putting together your privacy notices, or when you're gearing up to put this together, you have to keep in mind that while you're looking to be, future facing, there's a lot of past pulling out and culling of data collection practices, your processing practices that you need to be ready for and you need to be transparent about. So that's a key compliance issue. A couple of other things that stand out when you're thinking about consent. Individuals also have the ability to withdraw consent that they have provided. We will touch upon what those consequences of withdrawal are when we're talking about the other grounds of processing. But that effectively means that you need a user-facing system that enables individuals to actually come to you and say, okay, I'm done, I'm opting out, and actually having the corresponding internal processes to give effect to this right. If you're a company that does business not just in India, but across the globe, it's likely that you have some form of these processes in place already. But when we speak about purely domestic businesses, at least in our experience, because the law hasn't actually required it, most Indian companies aren't ready for this. So that's another operational challenge that arises when we're structuring processes for consent. 2 or 3 other key points that stand out when we're thinking about consent. It becomes a business's responsibility to be able to demonstrate that you've done your bit to collect consent. So maintenance of logs, screenshots, recording user journeys become an important part of your IT infrastructure requirements. Because, there are certain other regulations that require this already. For those of y'all who are prepping for compliance or who have already complied with CERT-In's new cybersecurity requirements, will already have begun processes to maintain your ICT logs. But now when we talk about logs, you need to start thinking about maintaining logs to show a user's journey, be able to demonstrate when a user clicked on the consent button, how they exercised their consent, what the processes were, is it time-stamped, have you got the geolocation in place? There's a lot to think about. And just from our learnings from the CERT-In exercise, log maintenance is a technical nightmare, right? Especially when you are thinking about the type of logs you need to keep in place, maintain for how long, etc. So that is also something that tech teams and security teams should start thinking about. One last key point before maybe we close the topic on consent is that the law creates a category of businesses or organizations called consent managers. And consent managers are basically companies that offer products to users to enable them to manage their consent preferences. I think for those of the easiest comparison is the account aggregator framework under that is regulated by the Reserve Bank of India. This version of the law creates the concept of consent managers, very, very similar to how account aggregators work in India today. As a consent manager, you will be required to be registered with the Data Protection Board of India, which is the authority that will be set up. And we are going to expect a lot of traction. I mean, the account aggregator framework, the success of that, I mean, I'll let y'all be the judge of it. But I expect a lot of interesting new business across the consent manager framework that this law creates.
Adya, if I can jump in,
Of course.
to be very careful about what we say about the account aggregator ecosystem, because BG Mahesh, the man behind the AO ecosystem, is in the audience.
Hi, Mahesh. No, I'm a big fan. I think it's incredible. And I just think
Unless we want Mahesh to come to both our houses and beat us up. Mahesh, we think that the account aggregator ecosystem is a raging success.
of course. And
But on
no,
the-
I just think with what is possible and the kind of choices that are given to users, and also keeping in mind the fact that most businesses don't have the ability to manage consent preferences by themselves. A system like a consent manager or an AA framework, and the AAs are limited, of course, to the financial services sector. But putting those together, the potential of what can arise, it's very, very exciting. And perhaps a very useful way to tackle the pains that consent compliance are actually going to throw up.
and equally importantly, I think here's proof that we don't have to copy from Singapore or Europe, right?
Yeah.
Here's an Indian experiment in the data management space that has worked really well. And that came out of a combination of industry consultations, RBI's brainwaves, all of that, right? So we can do it. And that's why I'm kind of hopeful that as we go through the government consultation process, answers will emerge that will solve some of the remaining puzzles in the bill.
Absolutely. So that's it on consent. But we have other grounds. Matthew, do you want to take this?
Because I can't shut up.
He's here. Yeah.
So again, I apologize. I'm one of those people. Oh, before we go on, we have a few questions. So Megha, firstly, I agree with you. There's a certain disharmony between the RBI and the SEBI and the IRDAs and the PFRDA standards on data security and cybersecurity and what is in the bill. What I would expect to see in the next 1 year is a degree of harmonization to the highest standard. But perhaps you could wait till Jan. We have a session on the new data bill in the financial services space coming up, and hopefully you'll join us for that. And we can then have a much longer conversation on the specifics and the differences or the lack of differences between explicit consent and informed consent, the words used by the RBI and the words used in this bill, right? But by and large, my expectation is that we will see a movement to the highest level, at least when it comes to questions of consent. In other parts of the bill, we might have to take a more nuanced approach, especially with payment data localization requirements. But by and large, I think this bill is going to be a positive, net positive, even for those companies which are regulated by the RBI. Abhishek, at the end of this slide, this question will have to be dealt with. What is deemed consent? Now, it's borrowed from Singapore. I apologize for that. Again, not horribly regret pushing the Singapore example as a great example of what to follow. However, I'd like, when you conceptually think about deemed consent, think about it as other grounds of processing, right? These are the other ways, non-consent based ways in which entities and the government can process data. What are these grounds? And I'm going to use simple examples. I give you my data voluntarily in the course of a commercial transaction. And it is reasonable that I should be expected to give that data. then the person can use that data. The person does not, the recipient can use that data. The recipient does not need to stop me in the middle and say, hey, sign my privacy consent release form, or anything silly like that. And that's a fairly simple, common sense approach to that. The government can, for enforcement of any laws, deem consent. Not too sure what that means. The government should have a absolute right to access data as long as its actions are consistent with the constitution. Deeming consent brings up the question, and this comes up in the case of private entities as well, as to whether a data subject can revoke that consent, right? Or where do we go from there? Why are we, the language of deemed consent is problematic because of a historical jurisprudence on what that means. So maybe a good idea for the government to evaluate whether this can be changed to other grounds of consent. But that said, conceptually, this is going to remain, right? For example, if you have medical emergencies, if you have health emergencies, or you're going to provide assistance to someone in a dangerous situation, all of those cases are deemed consent. Similarly, and anyone who's in HR in any organization should know, getting consent from an employee is fraught with questions of the imbalance between the employee and the employer. Is the consent freely given? Was there the sword of getting fired on top of it? How does it work? All of that. So the government is saying that as long as it's for the purposes related to employment, we'll deem consent, right? And good for multiple issues that we're dealing right now. Even expands it to cases of corporate espionage, etc. So all of that, insurance, all of that is resolved by this bill. There is an additional clause which talks about consent in public interest. The way it is worded, and again, I think an amateur is drafting a mistake. But the way it is worded right now, it appears that private companies can invoke the public interest grounds, right? And public interest grounds include M&A activity, combinations, corporate restructurings, etc. I'm guessing some really smart M&A lawyer squeezed this in. One should probably carefully evaluate its impact from a data governance, data security perspective. The fact that I gave Fitbit my health data is no reason to assume that I trust Google with it. Not that I don't trust Google with it, but I don't trust Google with it. And just because Google acquired Fitbit, it should not have the ability to take my data, no matter what your neighborhood friendly M&A lawyer says, right? And that's fairly simple. You can see the recent city controversy that's in the newspapers, right? And apparently there's a public interest in credit scoring. I refuse to. What does that mean? Anybody who's doing credit scoring can then take all my data? Let's just say, as a data subject who's the subject of this law, and as someone who has a right to privacy under the Constitution, I have very great issues with all of this. But all of this can be solved. Again, all of this can be solved in multiple nuanced ways. Some of it before the bill comes into board, some of it with rules and regulations after that, but all of these can be scored. There is a separate clause which says they're going to presume deemed consent for any fair and reasonable purpose that is going to be prescribed after looking at legitimate interests, etc. That's a marriage between that's a marriage between a common law principle of a value-based rule to a prescriptive approach that the continent takes and the Chinese take. To my mind, that is a mistake, and this needs to be reshaped. But broadly, expect government rules on what is a legitimate interest of a company in processing data. A fairly significant part of European data is processed in accordance with this requirement. So expect it to be fleshed out for this bill to work. We are still going to rely on consent. It's very early 2000s, right? Um, should businesses rely on legitimate interest instead of consent? Yes, but wait till the government clarifies that this is the manner in which it is required. So hang on, do not go the full hog and kind of build a data security architecture and collection architecture on the basis of consent. I am cautiously optimistic that we will learn from international experience and bring in a fairly fleshed out ground of legitimate interest, whereby significant parts of processing activity will not require consent, specific consent. Um, it does appear from the bill that if someone takes away your consent, you can go and look at other heads and say, okay, this I'm processing it under other heads. It's a bad idea, just like forum shopping, grounds of processing shopping, or ground swapping, whatever you may call it. It's ridiculous. It's outlawed in most mature data jurisdictions. I'm guessing this was a mistake, probably not well thought out. Again, we're hopeful that minor tweaks like this are going to be entertained by the government before the law becomes in force. Abhishek, I'm presuming from okay, Abhishek Javdekar had a question on whether if we work under the deemed consent protocols, whether a privacy notice is required. Go on, Adya.
I actually think that the way the draft is structured, Abhishek, your reading is right. It looks like you don't need to provide a notice when you are relying on other grounds. But I think that is more of a drafting issue as opposed to actual intent. Right. And let me know if you disagree, Matthew, Ajit, but I am pretty sure that the expectation is that notice is always provided.
Correct. I would agree. From a data governance perspective, from a fiduciary's obligation to fulfill its own data governance requirements, plus consumer protection requirements, 100 other reasons, I think a privacy notice would be mandated. I think it is amateurish drafting at that point, and therefore I'm hopeful that this will be resolved. Again, minor tweaks here and there. I don't think there are conceptual disagreements. I don't think there is any data lawyer that at least I've spoken to in India or in another country who would defend processing under the deemed consent provisions without a privacy notice. So cautiously optimistic that this would be solved. One more question, Adya, before I think I'll hand it over to you, which is from our neighborhood payments guru, Aditya Sengupta, who asks whether consent for data storage work when data collection and storage is required for regulatory. Yeah, so that's a express exception from the consent requirement. When I meet you for chai in Koramangala next, we can talk about it in detail. But by and large, if it's required for legal or regulatory reasons, you're allowed to keep it. And no matter how many changes are going to come into this bill before it becomes law, that won't change. And if it changes, it will be unconstitutional under what I now believe is a standalone, clear ground for constitutional challenge, what I call the stupidity ground, but the ground of manifest arbitrariness. There is no way that one law can ask you to keep a record and another law ask you not to keep that record. So yes, I hope that's clear.
Yeah, and just also stepping in here, if data subjects do have the ability to, for example, to exercise a right to seek the erasure of their data, but there's a very, very clear exception for situations where you're required to maintain it. So I don't think that this is going to be a major issue. Okay, so quickly moving on to the other controversial aspect, which is cross-border flows. And I think there's some disturbance from your end, I think.
Sorry, I'll go on.
Yeah. So with cross-border flows and localization, and maybe some history here would be helpful just to set the context, is that the previous iterations of this data protection bill created additional categories of personal data called sensitive personal data and critical personal data. And these categories of data were subject to more enhanced processing obligations, number one, and specifically were subject to different localization requirements. So with sensitive personal data, you would have to maintain one copy in India. Critical personal data couldn't leave the country at all. And obviously, there was a lot of pushback on this requirement, impracticable, also not in line with how modern data flows work and how modern industry works. So the government did relook at it with this version of the bill. But localization often goes hand in hand with cross-border data transfers. And maybe it's useful to touch upon what the expectation of a cross-border data transfer is. Now, under any data protection law, I think in any jurisdiction, the expectation is that when you are transferring data to another country, that country or the recipient of the data must adhere to a standard of data protection that is in line with the requirements of the transferor country's data protection requirements, right? Now, this is operationalized in different ways. So if you look at some countries, for example, the entity that is transferring data is required to make sure contractually that the recipient keeps, adheres to a standard of data protection. Some countries impose adequacy decisions, which means that the government thinks through, evaluates a recipient country's data protection laws and other laws and determines that, yes, this country is capable of providing a standard of data protection that is comparable to our country. There are different schemes, there are different contractual frameworks, there are different ways you can structure cross-border data transfers. What this bill does is remove all those different grounds for the transfer of data. And what it says is that data may be transferred to other countries. There are no distinctions between personal data, sensitive personal data, critical personal data. All categories of data are treated, the same way. But you can only transfer data to a country that is deemed adequate by the government. Now, principally, there isn't an issue with that. That's actually a sensible choice. The only problem I see with this bill is the fact that it doesn't allow for other grounds for transfer. There is only adequacy, and adequacy is usually, and we've seen this across the globe, we've seen it with the EU, we've seen it with other countries, often depends on geopolitical aspects, geopolitical tensions, diplomatic relationships. And the way the Indian outsourcing industry, for example, is structured, the way India acts as a hub for most things, when it comes to technology innovation, having a limited ground to transfer data, basing it on an adequacy decision is extremely limiting, which basically means that if I intend, or if I have servers, if I have customers, if I have sub-processors in countries that the Indian government doesn't deem adequate, I'm stuck with the localization requirement. And that is, I think, one major problem we see with the bill. There are fixes, right? There are fixes. You can impose different grounds. You can require transferring entities to actually do some kind of due diligence on the transferee, impose something called contractual clauses to make sure data is safeguarded, build in additional approval mechanisms. But a blanket adequacy decision could be problematic because it limits the ability for businesses to transfer data out of India. Another issue, and maybe not such a big issue, is that the bill doesn't set out the criteria for how an adequacy decision is going to be judged. Typically, what you would expect is at least principles to say that you need to perhaps look and see whether the recipient country has an adequate data protection framework, whether they have an independent data protection authority, whether there is an ability to bring claims in that jurisdiction for violations of privacy, etc. For those of you all who do business with EU and have been subject to a transfer impact assessment from European companies or American companies that are trying to transfer European data to India, will understand that there are ways, however painful, of making sure that businesses that seek to transfer data do their due diligence and remain responsible for compliance. The problem we see is that by not providing additional grounds for processing, we're still effectively stuck with localization, no matter what different industry experts may say. What's also notable when we're talking about cross-border data flows and localization is that there are exceptions, but those exceptions apply only for processing of legal claims, compliance with court orders, or prevention of crimes or investigation of offenses, etc. None of which are grounds that may be traditionally relied on by private entities and act more as exemptions for the government. So effectively, private companies, no matter, there's been a lot of rejoicing around the fact that localization doesn't exist, but effectively this is light localization. We're hoping that through consultations with the government, we can evolve this process a little bit. But right now, things look a little bleak when it comes to cross-border data transfers. Another aspect that really stands out with this bill is the positive obligation on businesses to give effect to data subject rights. Now, unlike previous versions of the bill, where you had rights like the right to be forgotten, etc., those have been removed from this iteration. The rights that are available to individuals or data subjects like you or me are limited to a couple of them. So you have the right to be informed about how your data is being processed, how businesses store your data, and who they transfer the data to. You have the ability to seek the correction and erasure of your personal data when businesses have no reason to hold on to it. As an individual, you have the right to grievance redressal or having your grievances addressed in an effective manner by the business that is collecting your data. And very interestingly, you have the right to nominate a legal heir or successor who can exercise your rights in the event of your death or incapacity, which is unusual, interesting. Don't see a major problem with that yet. But what this effectively means for businesses is, firstly, like we had mentioned earlier about building in processes to give effect to withdrawal of consent. Businesses also need to start thinking about developing systems that identify what data you have about an individual. Because if, as an individual, I approach a social media company to get a list of all the data they have about me and how it's been shared with third parties, as the organization, I actually need to have an inventory or map to enable me to answer that individual's right. So building in processes, and that can usually be done in the form of know your data exercises or data inventory or data mapping exercises. Anybody who's kind of struggled with GDPR compliance would have probably undertaken this process on some level in India. That becomes a crucial part of building in systems to address data subject rights. Another part is actually having the kind of UI or portal or external facing applications that will enable individuals to approach you. There are a lot of exciting companies that are doing some work in this space. And it may be time for businesses on some level to start evaluating these kind of products, right? If you can't build it in-house, there are actually great technology solutions that we've seen a lot of businesses use. Notably, you will also need to appoint a grievance redressal officer who will be the front-facing person to address grievances. If you are a significant data fiduciary, which means that you fall within a category of organizations that the central government deems as significant simply because of the kind of processing activities you're undertaking, the volume, the sensitivity of the data, etc. Then you will be required to appoint a data protection officer, and that data protection officer will have to be located in India. And that's not the case for all companies, just those companies that are deemed or will be deemed to be significant data fiduciaries. What's very, very interesting, I think, with this law, and I don't think we have really seen this with any other jurisdiction, is that for the first time, there are also duties and obligations that are imposed on data subjects like you or me, which means that we actually are statutorily obliged not to file frivolous complaints, not to furnish false particulars. I'm sure they mean well. It's just a surprising inclusion from my point of view within a legislation that is intended to protect your rights. I agree that there are problems, especially if you are at the receiving end of, ridiculous complaints, back-to-back complaints, silly or arbitrary complaints from your users, especially, I think, if you're a consumer-facing organization. But there are far more effective ways of tackling nuisance or, for the lack of a better word, annoying data subjects than imposing statutory penalties or financial penalties on those data subjects. I think it's very useful to look at countries like, or jurisdictions like the EU, where businesses can actually charge individuals for administrative costs and making ridiculous complaints as well when you're processing these complaints. And that might be a more appropriate way of tackling bad behavior from data subjects. It's a surprising addition. And I suspect that we're going to revisit this. I'd be surprised if this passed, honestly, considering the nature of what this law is intended to do and how it's intended to protect data subjects. So all in all, be ready to build processes, build systems, build protocols, set up teams to handle grievances from data subjects. Ajit, do you maybe want to take the security standards, which is another big part of this law?
Yep, sure. Hey, everybody, good afternoon. So primarily, if you look at the bill, the primary requirement of security controls haven't changed. The fact remains that the law still uses the term reasonable security standards and safeguards that you need to implement within the organization. What we suspect is going to be an additional compliance burden is the compliance surrounding the security safeguards that have been proposed under the bill. Firstly, something that you may want to note is that the obligation for complying with security safeguards as well as breach notifications under this law, unlike a lot of other international legislations we've seen, doesn't just stop at controllers or what we in India now want to call data fiduciaries. There is an obligation on both fiduciaries as well as independently on processors and sub-processors to comply with the law. So, for example, if you look at the GDPR, you'll focus that a majority of the liability on how the data is controlled and processed vests with the controller. But under the present iteration of the bill, these obligations of safeguarding data, safeguarding processing, ensuring that the processing of data is lawful, also ends up falling on data processors and sub-processors. We don't foresee a change in the concept of reasonable standards. So like we saw with the SPDI rules, we saw that your other sectoral compliances, RBI, SEBI, should be enough to meet with the base security standards that are proposed under the bill. Now, considering your IRPs and incident response plans and management mechanisms within an organization, once again, while the compliance with your reasonable standard remains the same, because of the differentiation of the classes of entities handling data, with data fiduciaries deciding control and data processors also having compliance requirements under the law, contractually as well as within an organization, you might want to ensure that the roles of organizations as well as expected contractual obligations are passed on to processors in a much more structured manner than we saw under the SPDI rules, because the SPDI rules at the end of the day applied equally without considering what sort of organization did what kind of business. But in relation to data processors specifically, you might want to ensure that contractual obligations involve instructions on what to do with your data, facts around DSRs, facts around breach reporting, which I'll get to in a minute. All of those are as well complied with. And within an organization as well, because of the kind of obligations that we see with just personal data existing and no sensitive personal data classification, you might want to ensure that these standards of data are complied with when you're dealing with your brand new IRP. When you look at the breach reporting requirement under the bill, that's also something interesting that they do. And again, a slightly different format as approached under other legislations. Unlike the GDPR, unlike a lot of other legislations around the world, we require that not just controllers, but as well as processors independently report data breaches to the Data Protection Board. Additionally, as a standard that was not previously seen under Indian law, you will also have to inform affected individuals, affected data principals about your personal data breaches. Now, the law very simply defines what an affected data principal is. It's anyone whose personal data has been affected by your breach. But something that's very interesting to note under the Data Protection Bill is that the scope of reporting is pretty narrow. You don't have to report every single data breach that occurs. You have to report just personal data breaches and specific kind of activities that may result in personal data breaches, unlike the massive certain obligations that we've seen. However, in addition to that, because cybersecurity reporting will still remain a major concern, we still suspect that certain reporting obligations still continue to exist, or obligations similar to the certain reporting requirements still continue to exist. But something that you might want to also flag is that while the certain had powers like this, we now have a specific authority, the Data Protection Board, also having the power to recommend urgent measures that you must adopt when you report a personal data breach. So you will now also have an independent authority who will be coming to you asking possibly a lot more invasive questioning than we have seen with the certain. And obviously, failure to notify and failure to report to affected individuals about your personal data breaches now end up carrying massive financial penalties. So compliance mechanisms around personal data breach reporting need to be built. In line with the Data Protection Board's requirements, we also see that consent compliance mechanisms also form a part of security compliance, simply because you now also have an additional class of entities being built. You have an additional class of entities called consent managers who have entered the or consent verification are in compliance with security standards. In addition to that, maintenance of logs, display of logs, passing on of information to the Data Protection Board also need to be rethought in compliance with these new standards, because you're going to be dealing with multiple different entities. You're going to be dealing with consent managers who will be one class of entities providing you with consent. You'll also be dealing with data processors who might want to deal with security compliance on their own. So if a DSR is raised with a processor instead of a data fiduciary, considering that under the law, a consent manager is also a data fiduciary, you need to essentially ensure that contractually you have a streamlined flow of reporting requirements within an organizational structure to ensure that you are in compliance with the law. Before moving on to,
just stepping in here, and Aditya, I'm just looking at your question because there are a bunch of questions in the queue, and I think it might be helpful to answer it in this context. And I'm going to go backwards. Aditya, I think when you are saying intermediaries, you mean data processors. Matthew, do you want to answer this? Because I see you've addressed this. Okay, why don't you jump in if you disagree with me? But an intermediary, such as a SaaS player or a sub-processor or a vendor, for all intents and purposes, is a data processor. The obligation to give effect to data subject requests, that primary liability lies with the controller now, or the data fiduciary. That's what that's the term that the Indian law uses. Basically, the entity that is responsible for the means and purposes of processing. If you are structured as a data processor, which means that you do not take independent decisions with respect to the processing activity, and you are processing on the basis of your controller or your customer's instructions, then if you do receive a request, and this is where I think the law is a little sketchy, it has not been clearly spelled out, unlike many other laws. How it typically works is that the processor or the intermediary is obliged to inform the controller, and it becomes the controller's responsibility to actually manage the grievance redressal process. The obligation to redress the complaint, redress the request does not lie with the intermediary. But I think the way the existing version of the law is structured is that it does lend some ambiguity as to what a processor or an intermediary's role is if they do receive a request. And I'm sure this can be fixed with a few drafting tweaks, and I'd assume this would be aligned with most global best practices, is that the intermediary would be obliged to inform the controller and assist the controller with actually responding to these requests. Another question, I think from an anonymous attendee, is that in terms of the nature of personal data processing with respect to significant data fiduciaries, how is sensitivity determined since data categorization is removed? That's a very good question. Again, there are, I think, when you look at the overall structure of the bill, less principles that will aid the government with this determination. My expectation is that we've got clearly established global principles of what sensitive personal data is. Things like health data, things like sexual orientation, things like biometrics. In some countries, like in India, financial information forms a part of sensitive personal data. Your religious views, your political beliefs, your trade union affiliations would all, I suspect, would fall within the scope of what sensitive personal data is. And while the existing law is silent on it, my expectation is that the government will rely on these global practices for what sensitive data is to determine whether a business is processing sensitive personal data and therefore should be classified as a significant data fiduciary. Matthew, Nikhil's got an interesting question on IP versus data. I'll let you take this.
They're just inviting me to rant. Yes, Nikhil. So Nikhil's question is basically whether the entire bill is, from his perspective, appears operational in nature, but there is barely a mention of privacy and nothing on privacy enhancing techniques. And what happens to the IP that is created on data gathered through deemed consent via public interest? So let me answer the first bit. You are right. There is very little mention of privacy. I'm guessing that's because the government attempt was to put in place the skeleton, and privacy concerns will hopefully be built in as we flesh out the skeleton. So like the skeleton, it identifies pathways, it identifies structures, but it does not give us, there is a lot of substantive privacy related issues that could creep in that has not been mentioned. Let's also not forget that under Justice Chandrachud, we've got a very, very active Supreme Court and presumably very active high courts who probably post Puttaswamy will be eager to flesh out privacy obligations. So perhaps that is not what the government was trying to solve here. And perhaps that is something that between case law, government consultations, a data protection bill, a data protection board, this will slowly get fleshed out. So yes, nothing on PET, right? Presumably nothing on dark patterns, right? Presumably intentionally, right? Because they haven't taken a position yet. They're probably evaluating where to go on all of these things. But the other question's interesting. What happens to the IP that is created on data gathered through deemed consent? I'm presuming you're talking about what happened to the algorithms that are trained on these data, or what happens to software that is created on the basis of preferences that are identified through the use of this data or metadata. In both these cases, that IP belongs to the creator, because the general province of IP law and its paradigms have not changed. So regardless of whether it's patent, limited application in India, or copyright, or in some cases trademarks, if that's possible, I'm not very sure. But for patent and copyright, IP will vest with the creator regardless of what role the data played in the creation of IP. AI, if you train your models on data that is derived from public sources, there is no obligation to contribute back to the public. I know we've had a lot of questions around data personally, Nikhil, you and I. Unfortunately, the bill at this point does not interfere with systems of IP creation. There is no contribute to the commons kind of clauses there. It's unlikely that those clauses will be built in, but one never knows. I don't see too much of a precedent globally for any of that. Naga Chetan has a very interesting question, which is credit score data being included as public interest use case. Does this mean that we need not ask the customer specifically when we pull a credit score or search publicly available data on the data principle, right? Presently, banks and FIs do take consent. So firstly, I do think that credit scoring being in the list of deemed consent provisions is problematic, to say the very least. I'm just going to dig out that construct and just call it out to you. It just says credit scoring, right? So presumably it's the use of data in public interest for credit scoring, right? So I'm presuming there has to be a public interest on top of it being for credit scoring. Secondly, I'm guessing they're saying it's not for collection of credit score data, but it is for use in credit scoring. So I'm guessing you're talking about using data that is collected through consent or through consent and thereafter being used for credit scoring. However, not very clear at this point. There are very few global precedents for something like this. We'll have to wait for the government to answer what they exactly mean by this. Surely, if they meant that banks can go around and pull customer data without taking consent, that would firstly raise red flags at the RBI, but secondly, even more importantly, raise red flags under Puttaswamy and the various right to privacy related litigation, including some of the other decisions. So it can't be that they're giving a free for all to the credit scoring companies and the banks and the digital lenders. That's very, very clearly will not be the intention. But what the intention is, we'll know only once clarifications are in.
There is also an interesting question on whether personal data that has been collected digitally and then printed and that paper got lost, would such a scenario be a personal data breach for the purposes of the Act? And I think this is the fundamental problem with how the applicability clause or the applicability provision within the Act has been drafted. Because theoretically, offline personal data is not regulated by the provisions of the Act. For situations where digital data may be at a later stage, printed on paper, I'm inclined to think that the law would still continue to apply to it. But I do think that's a huge drafting oversight. And again, I don't think that's the expectation. But we'll have to wait and hope for drafting fixes.
Right, yes, and obviously it will have to be reported to certain, so all of that will then be triggered. Will privacy notices currently provided in internal applications be mandated to have DPNs in all scheduled languages? Very simple, yes, it should be. No way out of that one. Tanvi, can data held by companies be called upon by the board, and in what instances? The bill gives the board broad powers to determine non-compliances. So can I would imagine so. The Indian government and various arms of the government, including enforcement arms, already have the right to require companies to disclose data to it. So this bill does not give them powers that is not already available with the different other arms of the government. Can we expect notices from the board requesting info? Practically not, unless you fall within one of the offenses. So what we've seen, and this is not a answer based on the bill, this is an answer based on, let's say, certain practices and how they do it. The moment there is a bill, you can expect, the moment there is a breach and you don't comply with the breach notification requirements, or you comply half-heartedly, or the board identifies issues with your compliance of the breach notifications or your actions, then we can expect for requests for further information, investigations, for them to come to your office and sit and investigate and all of that. Blanket investigations, I would imagine, would be probably not going to happen, because the board will be busy, right? We've already seen how busy certain is with their managing their breach, and the board's powers are much, much wider. So I don't think we should expect the board to be investigative, except where maybe it is responding to complaints received. So in my head, and there's nothing in the statute that says this, but in my head there might be something. The Competition Commission is a good comparable. There might be a investigative arm of the board that is going to investigate complaints received by the board, much like the DG at the Competition Commission. Expect that to happen. Expect them to ask you for disclosures of data. Expect them to pass through that data. It is a very evolved process that the CC has. Presumably, similarly evolved processes will be put in. But as long as you comply with the rest of the act, both in the letter and the spirit, I think you should be fine. And I don't think you should expect crazy investigations like you didn't in the Competition Commission, right? For the first few years, while they're setting up the architecture, the sheer manpower required to operationalize this would be huge. And commensurate with that, significant employment opportunities for young data lawyers, looking at helping the DG and also for litigators on both sides. But yes, on that count, given the amount of time that we have, shall we quickly move on to the next one? Ajit?
Yep.
Quickly though, please.
Yeah. So the bill essentially proposes some additional compliance requirements when you're dealing with children's data, right? So firstly, once again, in stark contrast to a lot of other legislations, we still say that the age of majority for data protection, for the applicability of the data protection legislation as is instead of additional protections is 18 years of age. We've seen countries in the GDPR we've seen the GDPR propose thresholds as low as 13 years of age. So as in essence, what this means is that you would be required to undertake that higher level of compliance for a child that's 7 years of age, or someone who's practically 17 years of age. And this is problematic in some instances because of how the bill is structured. Firstly, this is because you have a large business sector, you have edtech, adtech, you have the social media sectors requiring to undertake additional compliance requirements under the bill simply because you're dealing with children's data. One of the first things that is of interest here is that when you're dealing with the definition of a data principal under the bill, it says that for every child, the parent of that child will also be considered to be a data principal. So what this essentially means is that for the same set of data, or for one kind of data, or for one data point, you'll have not one data principal but two data principals acting on it. What the bill doesn't do is give complete control to the parent, but instead what it says is that the data principal for such kinds of data includes the parent, which means that you essentially have two different people dealing with the same kind of data. What this practically also means is that when it comes to questions of exercising data subject rights by children, you could essentially contemplate situations wherein parents exercise DSRs for their 16-year-old, 17-year-old on their behalf, which is something that might be problematic in sectors such as edtech and the social media sectors, where children over and above the age of 14, 15 usually exert control over their own data when dealing with these platforms. Something that is also an interesting inclusion is that you need to have verifiable parental consent when you're collecting the data of children. Once again, we don't really know what verifiable parental consent really means. This seems to have been lifted off, once again, other legislations. A huge inspiration of verifiable parental consent is the Children's Online Privacy Protection Act in the US, which practically provide some guidance as to what you might want to do to showcase verifiable parental consent. Some interesting mechanisms include base credit transactions using a parent's credit card, having video-based consent, requiring signed consent forms, emails, faxes, etc. You could also engage in email binding, bind the email of the parent to the account so that you can showcase consent verification through that means. There are a couple of restrictions additionally also placed on the processing of children's data. You may not process a child's data when you think that the processing of that data would result in harm to the child. But once again, the exact standard of harm or what is considered harm hasn't been really defined under the bill. And it's left to the business's best interest or the business's best prudence to determine what harm to a child essentially means. Additionally, there are three major restrictions in relation to the processing of data relating to children. You cannot track children using their data. Behavioral monitoring of children is also prohibited. And targeted advertising towards children, this is something that is going to prove problematic to sectors such as the edtech and adtech industry, where you will have to develop mechanisms to deal essentially with targeted advertising of children. You will not be able to undertake such activities, especially when it arises out of children using accounts on specific platforms. You will have to be able to create mechanisms to differentiate between when you're processing a child's data and when you're processing an adult's data. Additionally, in line with all the other penalties that are imposed under the bill, we have a high stakes financial penalty imposed on the processing of children's data. So when you're dealing with children's data, the formula essentially should be to try and keep track of data belonging to children, data belonging to parents, and the correlation of that data in an inventory or a map being of utmost importance, specifically because two sets of people are dealing with the same kind of data. Matthew, you want to take over the next slide?
Sure. We seem to be running very quickly through stuff. Okay, I'm going to quickly run through this. There is a data protection board that is probably going to be both investigative as well as adjudicatory. There is a lot of criticism in the media for the lack of independence of the board. The board will be appointed by the government. As I was discussing with a data lawyer a while ago, the SEBI is appointed by the government. The Competition Commission of India is appointed by the government. The TRAI is appointed by the government. I don't see why the board should not be appointed by the government. The board has the powers of a civil court. The board has the obligation to comply with natural justice, which means the board has to hear everyone and the board has to give reasoned orders. The board, appeals from the board will go to the High Court. Under the Data Protection Bill, also supervisory jurisdiction under 227, and writ powers under 226 and to the Supreme Court under Article 12, I really don't think, unless there is a visceral lack of trust with the government and the courts, I think the Data Protection Board is well structured to protect data rights. Right? We could go on a existential angst-ridden rant against courts in India. But clearly, I think that is historically wrong. We have always had activists with changes in levels of activism, but we've got activist courts who've always risen up to protect rights of citizens, and I think this within that paradigm this works. The bill provides something called voluntary undertakings. This is a process by which you can disclose issues with your compliance system and get forgiven for it, similar to a compounding procedure under the Companies Act. So that's permissible. The Data Protection Board is allowed to tell parties that certain disputes should be the subject of mediation. Good, I'm all for mediation. I'm guessing well-intentioned. We'll see how it works. The High Court will see appeal, so that's done. And there are some fairly large fines in the offing. Right now, Schedule 1 is up to 250 crores, can go up to 500 crores. But at this point, 250 crores seems to be the largest fine possible, which is great. I think I know there have been complaints when I talk to clients, but I think it's time that companies prioritize data governance and data ethics within how they collect and how they process and how they store data. Sorry for running quickly past this, but this is probably the least interesting bits anyway. What do you need to do? Remember, this is a skeletal framework. You need to start putting up a comprehensive data map. Please, and if you don't know what a data map is, call us. But please identify what all data you collect, how you collect it, and what the grounds of processing for those data are, where it's stored, where the servers are, etc. It's already time to create a gap analysis to try and figure out what the gaps are in the protection in your present system of treatment of data and what the law requires. Start mapping out sub-processors, because hey, you need to start thinking about how they use your data and whether that's permissible and whether consent has been taken for all of that and all of that. Using all of this, start preparing privacy notices. Look at the scale at which you need to send out privacy notices for historical processing. And of course, take a deep breath and expect further regulation. That's broadly what you need to do. We've been working with large corporates for the last year and a half on preparing a comprehensive data map. We've been working on gap analysis and we've been working on mapping out sub-processors. This process takes over a year for most of the larger organizations. If you're really small, of course not. Therefore, do not say, oh, I'm going to wait until the act is final. Regardless of what act comes in, you will need a map, you will need a gap analysis. The basic fundamentals of gaps will remain. The basic fundamental principles will remain, and therefore the basic gaps will remain the same. And do start mapping out sub-processors, including from an employee perspective. For example, I had a client who asked me, you're telling me Bamboo HR is a sub-processor? Yes, Bamboo HR is a sub-processor. If you're using Google servers, Google is a sub-processor. If you're using Amazon servers, again, there'll be processing that they'll do. If you're using Alexa, that's a very large sub-processor. So please get the map in order, look at privacy notices. The rest you can probably do once we have a final shape. But please get active right now. I've seen a lot of times wasted in multiple fora crying about how the bill is unfair, how privacy is not taken care of, how I'm an Indian citizen and this is disrespectful of Puttaswamy. Yes, all of that, yes, valid, relevant. Many of those may be instinctive reactions, but as a corporation, it's time to get into action and try and start doing the minimum to enable you to comply with this law, which from our reading of the tea leaves, and we've been fairly accurate, except towards the end of the last bill. From our reading of the tea leaves, it does look like this will be law sooner rather than later. We've bored you for an hour and a half, so I'm not going to take you longer. What we do have planned for you in Jan is 10 separate presentations on how the data protection bill is going to affect existing HR tech, financial services, energy, software, drones, e-commerce, healthcare, ed tech. By technology, we typically mean outsourcing companies and telecommunication companies. We will talk about how this law will, to use Mega's words, harmonize with existing regulations and what the changes are that each of these industries will require to implement once this bill becomes law. So if there's interest, do write in. We'll take a note and write to you once these are notified. But otherwise, feel free to watch our LinkedIn space. We'll put it up, and hopefully we'll have smaller groups talking about the data issues that affect them. Thank you. Thank you for patiently listening to us. If someone wants to say anything, I'm happy to, put your hand up, and I'm happy to, I think, allow you to jump in and ask questions, or if there's lack of clarity, or you want to say something and comment on the law, happy to hear that too. We will be consulting with the government on the bill, and therefore, if you have thoughts from your industry perspective on what we should raise with the government, do write in. We'd love to hear your thoughts. All right, so on that note, it does look like everyone is poured out of their skull. Thank you again. I think we will close this for now. And you always, I presume the amount of shouting we do on LinkedIn, I presume you have all our email IDs. If you do want to get in touch, please do.
Thank you.
Thank you.